Court of Appeal in Abuja, Nigeria's capital, has reserved judgment in an application by the federal government seeking a stay of execution of the court's judgment that ordered the release of the leader of the Indigenous People of Biafra, IPOB, Mr. Nnamdi Kanu. Justice Haruna Sanami, who led a three-man panel, announced that a date for delivery of judgment will be communicated to the parties when ready after counsels adopted their written addresses.
While arguing its motion for a stay of execution, counsel for the federal government, David Kaswe, told the court that Nnamdi Kanu is a huge threat to national security and must be kept in detention for the relative peace in the southeast and the whole country, pending the resolution of an appeal already filed by the Supreme Court. He added that Kanu is a flight risk and would escape out of the country if the judgment ordered his release was not stayed. Now, to help us get a better understanding of the court's decision, we have Comrade Fidelis Ede, he's a public affairs analyst, and also the executive director, Service Accord Initiative. Thank you for joining us, Comrade Ede.
My honor. Good morning.
Morning to you, sir. Now, quickly give us your assessment of the entire Nnamdi Kanu saga and the court's decision yesterday.
Well, I think what we have now is very difficult to contemplate strictly within the concept of law, given the position of the Attorney General of the Federation. If you look at the whole process, you will recall, for instance, that the appeal for political solution was high and made by so many interest group, cultural, religious, and what have you. In one occasion, a statesman, a high Igbo leader, Chief Mbazilika Amechi, led even a delegation, pleaded with the president that Nnamdi be released to him and that eventually he will be tamed. But the president in that occasion said that he did prepare they allow the course of justice. It is at this point that the current position of the is becoming a bit worrisome, in the sense that if you look at Section 174 of the Constitution, from where the Attorney General of the Federation is drawing his powers, it's very clear on his role to prosecute criminal cases and even apprehend those that are ongoing. But if you look at Section 3, I think that is where the challenge lies in terms of how do we begin to interpret the role of the Accountant General of the Attorney General of the Federation, whether what he's doing currently is in the interest of justice, whether it is within the prevention of abuse of legal process, or whether in the public interest. I raise this aspect because one would have thought that with the pronouncement and judgment of the Court of Appeal, that what the AG needed to do, since the issue rests on jurisdiction. And what is it that the court has said? The court interpreted the manner of the rendition of Nnamdi Kanu. And if the jurisdiction, if the court said that that case ought not to have even been heard by any court, what else is the Attorney General pursuing? How can it be now that he is staying, by way of his recent position, the Court of Appeal judgment, when the course of justice to an extent has taken its course? And this brings to mind the case of Arero versus the state, where the Supreme Court then interpreted the discretionary power of the Attorney General of the Federation as if it's unlimited, but it is not. So it is worrisome that after the Court of Appeals judgment, that the Attorney General is still using his own powers to question the judgment and now trying to approach the Supreme Court. But even at that, the question will be asked, what best will serve the interest of justice in the Southeast, if not the justice of the Court of Appeal? can the Attorney General on his own constitute himself into a court to decide the fate of the Southeast and to an extent how that zone should be conducted? I think at this point, we must begin now to look at whether the appointment of the Attorney General as an appointee of government, a political appointee of Minister of Justice, and as well as the Chief Law Officer, whether there are no conflict of interest. This is where I think the court must also begin to assert itself, whether a public officer, no matter the repute, no matter the status, can begin to question the authority of the court, taking cognizance of Section 6 sub 6 of the Constitution that empowers the court to be able to render justice and question every legal issues in Nigeria.
I mean, this is another conversation about rule of law as well. And lots of people would ask, what exactly is rule of law? Evidaisi said it's the supremacy of the law over the rulers and the ruled, and it's the law really being supreme here. Now let's talk about another angle that may or may not sway the case some way. Now, this Nigerian newspaper reports that Michael Zekome had said that Nnamdi Kanu is terminally ill, needs surgery urgently. Do you think that this in any way might sway the decision of the Attorney General?
You know, just like in the case I've raised, what is obvious in this case is that the rule of law at this point is no longer being allowed. Recall also that we had a UN group that has also offered their own opinion and had even not only called for immediate release of Kanu, but said that he should be compensated by the Kenyan and Nigerian government. So the point is that we are at a point where the state, is holding a citizen captive. And because the power of the state is enormous, now being exercised by the Attorney General, you discover there is no further recourse. So the position of Zekweme, as long as the Attorney General is concerned, is seen just as a client who is making a case, a lawyer making a case for his client. But that is what it should not be. What should be is that we'll have a court of competent jurisdiction that has discharged and rendered a competent judgment, a judgment that is unassailable. But look at the other angle of it. Assuming the Supreme Court now takes a position to uphold the judgment of the Court of Appeal, what will be the political implication? Where is the rule of law on the position of the Attorney General? But if the Supreme Court decides to also give judgment in favor of the Attorney General, would it have achieved the purpose for which the Attorney General is trying to advance in the protection of life and property and the normalcy of conduct of affairs in Southeast? These are questions, I believe, if the Attorney General has considered in all ramifications, I would have thought that the Court of Appeal judgment provides even an opportunity for political solution. His logic about whether Nnamdi was discharged but not acquitted is something that would have been sorted out at the level of trying to release Nnamdi to under certain conditions so that he no longer be allowed excesses, which is what the Attorney General is trying to advance. But in all cases, I think the course of justice is no longer being served, and the rule of law is not being advanced.
There's so much more that we would have loved to talk about. Whether he's a flight risk, whether national security, of course, comes first. Compared to human rights here in Nigeria. But we've sadly run out of time. We will be following the case. It's an ongoing case. It's been on for a while now, and we would love to bring you back again to, of course, share your analysis. But thank you so much for your time this morning.
Thank you. My honor.